Good morning and welcome to the ParkBridge Wealth Management Fall Webinar Series. This program is entitled Snowbird Domicile and Choice of Law. As always, my name is Jonathan Shenkman and I'm the President and Chief Investment Officer of ParkBridge Wealth Management. In that role, I serve in a fiduciary capacity to help my clients achieve their financial objectives. The goal of these programs is to bring professionals together to help them better serve their clients, and this is done by educating attendees on the latest topics in wealth planning and by encouraging collaboration between a client's attorney, CPA, and financial advisor where appropriate. My practice focuses on working with high net worth families, businesses, and not for profits. I manage individual investment portfolios, trust accounts, corporate retirement plans, and endowments to help my clients achieve their financial goals. In addition to the 20 or so events I run every year, I also do a fair amount of writing on the topics of investing and financial planning. You can read my work in a variety of periodicals, including Barron's, CNBC, Forbes, Kiplinger, The Wall Street Journal, and Trust and Estates Magazine, to name just a few. You can see all my work on my website at parkbridgewealth.com/articles or by following me on social media at Jonathan on Money. Additionally, you can check out my weekly podcast, which is also called Jonathan on Money, and you can listen to that on Apple, Spotify, or wherever you get your podcasts. Today, we're privileged to hear from Bruce Steiner, who's of counsel at Kleinberg Kaplan based in New York. And Bruce has over 40 years of experience in the areas of taxation, estate planning, business succession planning, and estate and trust administration. He's a frequent lecturer at continuing education programs for bar associations, CPAs, and other professionals. He's co-author of CCH's Roth IRA Answer Book, and Bruce is a regular on my webinars, and his partnership and insights are always appreciated. Today, Bruce will be speaking about Snowbird Domicile and Choice of Law. And with that introduction, I'll now turn the program over to Bruce.
Thanks, Jonathan, and thanks for having me back. We're going to talk today basically about some of the differences among the different states. We'll focus a bit on New York, New Jersey, and Florida, just because those are the states that I practice in, but some of the concepts will work similarly in the other states. You basically have some choices to make when you pick a state. Do you like winter? Or do you like summer? And some people prefer one, and some people prefer the others. The other. Well, I can't comment about the choice of weather, but I can comment about the tax consequences and some of the other procedural differences among the states. There's a federal estate and gift tax and GST tax, and that applies in every state. The exemption is $13,990,000. It will be $15 million indexed for inflation beginning next year. There's portability for the federal estate tax, so a couple between them can get $30 million, even if the first spouse leaves everything to the second spouse. The executor of the first spouse's estate can elect portability, and then the surviving spouse inherits the first spouse's unused exclusion amount. There is, however, no portability for the GST exemption. So leaving everything to your spouse outright is just fine, almost just fine for estate tax. The portability amount is not indexed for inflation. For many people, that's not a factor. But if you need two GST exemptions, if between you have more than $15 million, you have to do some additional planning. You then have to overlay state, estate, and inheritance taxes. It's actually fewer. Well, it is about a third. There's 12 states in the District of Columbia that have a state estate tax, and then I think there's 5 states that have a state inheritance tax. I think Maryland is the only one that has both of them. And these taxes vary from state to state as to what the exemptions are, how they treat gifts made during lifetime, how they treat Q-tip elections. So you really have to check the state law in whatever state you live in and whatever state you own property in, because they vary. 2 states have portability for state estate taxes, Hawaii and Maryland. I wrote a paper for Kleinberg on comparing the different state estate taxes. And if anyone subscribes to Kleinberg, if you don't, I strongly encourage you to subscribe to it. just go to LeinbergServices.com. I'm not an owner of Leinberg, but I highly recommend it. The New York estate tax, and that's the state where I'm physically located most of the time, is the exclusion is 7,160,000, which is less than the federal. It's actually what the federal would have been, but for the 2017 and 2025 changes in the federal law. If those two federal laws had never been passed, that's what the federal exclusion amount would be today. And it's indexed, but that exclusion amount is phased out between 100% and 105% of the exclusion amount. So on an estate of $7,518,000, only a few $100,000 above the exclusion amount, you get no exclusion amount and you pay over $700,000 of estate tax. So if somebody is terminally ill and they're worth $7,518,000, the best thing they could do would be to light a fire and burn 300 and some $1,000 to get their estate down to $7,160,000. Actually, what we do is we put a clause in the will that says that if I'd have more left over after taxes than the amount that would reduce my tax by more than it would reduce my estate goes to charity. So I would have $7,160,000 go to my family. I'd have $358,000 go to charity and pay no estate tax. There's no portability. New Jersey has an inheritance tax. At one time, everybody was subject to it. Now, close family members are exempt and others pay up to 16%. And people who get hit by that tend to be very unhappy about it. In New Jersey, you can reduce that tax tremendously by providing for people in trust rather than outright. And as long as nobody has any entitlement to anything, the tax is not due until the money is actually paid out from the trust. And since New Jersey has repealed its rule against perpetuities, that could be never. So the state will offer you a deal. They'll say, if you give us this much money now, we'll consider that full payment. And the deal is always a deal you can't refuse. I've never had a case where somebody did not accept the deal. Florida has no estate or inheritance tax. Florida also has no income tax. Of course, it has other features. It has hurricanes, and nowadays it may be harder to get vaccines in Florida. So you pick the state you want. State, estate, and inheritance taxes are based on domicile, as well as assets located in the state, real and tangible property located in the state. So we have somebody in New York who's a bit over that 7,160,000, up over by enough that a charitable bequest won't solve the problem. So one of the things they can do is buy a piece of real estate in a state that doesn't have a state estate tax, or you can buy gold coins or gold bars and store them in some other state that doesn't have a state estate tax, and somebody is actually about to do one of those things. And what is domicile? Domicile is based on all of the facts and circumstances. Where do you really live? In two interesting New York cases, they were income tax cases, but domicile is domicile. And you can easily find those cases if you search online. The Black case, the taxpayer divided his time between New York and Dallas, and the key fact was that he moved his dog. In other words, moving your dog counts for a lot more than changing your driver's license and your voter registration, because changing your driver's license and your voter registration doesn't change your life. Your life went on the same as it did before, but moving your dog changes your life. I didn't really quite understand that, because wouldn't your dog be with you? Wouldn't you bring the dog with you wherever you went? But maybe not. The Patrick case is an interesting love story. The the taxpayer got divorced, and then he looked up his old high school girlfriend. He found her in Paris. Unfortunately, she was married to somebody else, so he had to steal her away, and then he married her. And the key facts there, even though he divided his time between New York and Paris, was that his wife lived in Paris, and he paid all the French taxes as a resident. And of course, the French taxes are higher, much higher than taxes are here. So nobody would do that unless they were really, thought they were living there. And he won his New York case. Some New Jersey domicile cases, again, they're interesting to look at. Unanui is the family that owned Goya Foods, and there was and the decedent had spent a lot of time in Puerto Rico, and the child who was basically cut out claimed forced heirship under Puerto Rican law, and the New Jersey court didn't buy that. I don't know whether it was because they didn't like forced heirship or because they thought that the case was a little bit of a stretch. I think it was Gilmore, the person had moved from New York to live with a family member in New Jersey for about 10 days and then went into a nursing home, and the 10 days was enough to change her domicile. So you really have to look at the facts of each case. Your domicile continues until you acquire a new one. And the classic case is Jones Estate. It's an Iowa case from 1921. The decedent moved from Wales to the United States in 1883. In 1915, he sold his property and was moving back to Wales, and he sailed on the Lusitania, which, as we all know, never made it there. So where was he domiciled? He was domiciled in Iowa, even though he sold everything he had in Iowa and was on the boat moving to his new home in Wales, where he never made it there. So he never acquired a new domicile. So, for example, if I sell my house in New York or New Jersey, and I buy a house in Florida, and I put and the moving van picks up my stuff, and I get in my car and I drive down to my new home in Florida, and I pull into my driveway, and I step out of the car, and I fall on and I slip on the ice, and I hit my head on the concrete, and I die from the fall. My domicile is still New York because I never moved into my new home. So what to do to change your domicile, and it's not just Florida. If I want to change my domicile to any state, so you do the procedural things, but those are the less important things. It's how did your lifestyle change? What are you doing there? It helps to actually vote rather than register to vote. It helps to be active in things down there. It helps to move your important artworks and your pets to Florida, and it helps if your family is there, and it helps if you spend your holidays, your Thanksgiving dinner, your whatever, your Christmas or your Hanukkah or your Ramadan, whatever your celebrations are, if they're in your home in the new state. Planning for state estate and inheritance taxes is complicated because they don't all match the federal. The exclusion amounts are different. The portability is different. In some states, your federal elections or non-elections are binding for state purposes. In some states, the state tax is completely independent of the federal. And there are variations among that. So you have to look at your particular state and how it works. A couple of and in the planning, so in a state like New York, where the federal elections are controlling for New York, the typical plan limits the credit shelter to the New York exclusion amount, call it 7 instead of 15, and then leaves the rest, let's say, in a marital trust, and you can make a reverse Q-tip election. We talked about the Santa Claus. If it would say, if you'd be better off having a smaller estate, you have a charitable bequest. Unlike most, if not all the other states, New York looks through a single member LLC. So a New Yorker who buys a property in another state can have it in a single member LLC, and it will be treated as theirs. In most states, the LLC is treated as personal property, but New York looks through it. and vice versa. If somebody in another state has a single member LLC with property in New York, that would be treated as a New York asset, although most other states it doesn't work that way. So you can have inconsistent results between two states. New York includes gifts if made within 3 years of death. Some states is like the federal, the gifts at any time are taken into account in calculating the state estate tax. And some states stick to the way the old state death tax credit was calculated and ignore assets that are and ignore gifts even if made the day before death. When New York did that, we saved somebody many hundreds of thousands of dollars. The week before she died, she gave away all her high basis assets. She gave away all her bonds. She gave away about $8 million worth of bonds, and that got those assets out of her estate for estate tax purposes. New York plugged that. Some other states have not yet plugged that, and it works in some states. The New Jersey inheritance tax, as we talked about before, is a compromise tax if the interests are contingent, and that will substantially reduce the tax. So you provide for people in trust rather than outright, which we would normally do anyway for all kinds of asset protection reasons. It keeps it out of their estates and protects against creditors and predators and spouses. State and local income taxes, they range up to New York can get up to that's old. New York changed that. I'm sorry. I think it's now 10 and 3/4 in New York if you're above some I think $25 million. So you can get up to around 14 in New York, and you're at 10 and 3/4 in Connecticut. You're at 13.3 in California. And for the most part, they're no longer deductible for against your federal income tax, although subject to a small exception, which can go up to $40,000 for middle income taxpayers. High income taxpayers only get 10. Many states have different ways of determining when you're a resident for state income tax purposes. New York and New Jersey say if you're domiciled in the state or if you have a permanent place of abode and you're physically there more than 183 days. And in Barker, the taxpayer lived in Connecticut, worked in Manhattan, had a vacation home in the Hamptons, and he was there 20 days a year, but he was more than 183 days in the state. He was a resident. But then in Obus, a vacation home in the Adirondacks, they said wasn't really a permanent place of abode. I don't know what the difference was. In either case, you could have been there year round, but you wouldn't. I'll touch very briefly on state income taxation of estates and trusts because I know my friend and former colleague Andy Katzenberg is going to do a whole presentation on this, Jonathan, for you in a couple of weeks. Estates of domiciliaries are treated as resident estates with a small exception in New Jersey. Different states have different ways of determining when a trust is taxable in that state, and there are lots of variations and exceptions. So you can often arrange to have trusts not be taxable in any state, and that's what we try to do if it's practical. The probate procedures vary. It's trivial in New Jersey. The court clerks fill out the forms for you. It's a little bit of work, but not all that difficult in most cases in Florida and in New York. And everybody says it's really hard in California. So in California, you can do a revocable trust and do a workaround. In Florida and in Kentucky, a personal representative has to be a relative or a Florida resident. So again, if the person you want is not a relative or a Florida resident or Kentucky resident, a revocable trust is your workaround, or you can pick your second choice. But in Florida, the court does not have anything to do with trusts under the will. In New York, in most states, the court issues letters of trusteeship, and you go back to the court when you change trustees. In Florida, the testamentary trust is like a trust under a will. Your personal representatives commissions in about half the states, there's a statutory schedule. In some of those states, the courts can adjust it upward or downward, or in some states, they can increase it for extraordinary services. There's only about 5 or 6 states that have fee schedules, statutory schedules for trustees. Uh, so what I like to do if I'm doing a will that creates trusts or a trust agreement governed by the law of some state, one of the other 45 or 44 states, is I put something in the will that says that individual trustees' commissions will be based upon the statutory schedule of, and I pick a state that does have a schedule, and that minimizes the amount of litigation that we have or disputes that we have over those commissions. There's a couple of quirky rules on lawyers as personal representative or executive. In New York, without a disclosure that you can pick anybody you want, and that if you pick your lawyer, the lawyer will get commissions in addition to being able to hire their own law firm. In New York, without that disclosure, you only get a half a commission if you're an attorney executive. In Florida, without the disclosure, you get zero commission if you're the attorney and the if you're the attorney and the personal representative. Florida has a statutory schedule of presumed reasonable attorney's fees for an estate administration, but you can agree to work on a time basis. And like most law firms, we handle estates on a time basis. It usually comes out substantially lower, although if you have a very difficult estate, it could be higher. But if you did it on the schedule, you could ask the court to give you additional compensation because it was difficult and complicated. Uh, California has a statutory schedule, and it's hard to get it adjusted upward. So since there's a cap, it tends to become a floor, because if you have trouble getting paid for your time on the hard ones, you got to get paid more than your time on the easy ones. So again, a revocable trust is a workaround. It lets the lawyer collect their regular fees. Florida has a schedule of presumed reasonable attorney's fees in a revocable trust, which is 75% of what it would be in an estate. Uh, Continuing trusts, again, only about 5 or 6 states, including New York and Florida, have statutory schedules for trustees' commissions. So again, for avoidance of doubt, I like to say it'll be based upon a particular state schedule, even if it's a different state, just to have an objective test. About 2/3 of the states, including New Jersey and Florida, have the Uniform Trust Code. It's not exactly uniform. Many of them have varied it a bit, but basically it makes it a whole lot easier to modify trusts. So if I have a choice, I like to have a trust governed by the law of one of those states. Unfortunately, New York is not one of them, but about 2/3 of the states are, including New Jersey and Florida and most of the others. The rule against perpetuities varies. That's basically how long a trust can last. At the common law, it was lives in being at the inception plus 21 years. So if I create a trust today, it could be for the lives of my children and grandchildren, and then 21 years after the death of the last one. Many states have longer periods. It's 1,000 years in Florida, and some states like New Jersey have repealed the rule entirely, so it can last forever. All things being equal, I like to have a trust governed by the law of a state that has either a very long permissible period or an unlimited period. Decanting is a way to modify trusts. Florida was the first state to allow it in 1940. About 2/3 of the states, including Florida, including New York, but not New Jersey, have decanting statutes that authorize decanting. It's possible in many cases to decant under common law if the trustees have complete discretion to distribute principal, and I like to put a provision in wills and trusts that specifically authorize decanting. Elective share. Every state except Georgia, every common law state except Georgia has an elective share, but they vary as to what's included, how much it is, how you treat life estates, income interest, and who pays it. Florida is 30% of the estate. New Jersey is a third, with a very complicated way of calculating it. And in New Jersey and Florida, trusts get partial credit in many cases. New York, it's a third outright, which is much harder to satisfy because it's got to be outright. But if you give the spouse a trust that's much bigger than a third, the spouse might accept it. In New Jersey, it's a third of the augmented estate with lots of things, additional things included. Interorum clauses that a challenger of a will forfeits are not valid in Florida. So one workaround might be to create a revocable trust in another state. Community property gets a full basis step up at the first spouse's death. And Alaska, Florida, Kentucky, South Dakota, and Tennessee allow you to create a community property trust, even if you don't live in that state, which is an interesting thing to do. About 16 states, common law states, recognize community property by statute. If you move from, say, California to, say, New York or Florida, it probably would have to be recognized in those other states as well, but they don't have a statute. Florida has some very, very complicated homestead rules, which give you creditor protection and limit who you can leave your homestead to. About half the states have tenancy by the entirety, which means that a spouse's own property, such that neither spouse can convey it without the other spouse joining. In New York, it's available only for real estate and co-ops. New Jersey and Florida, it's available for bank accounts, even for anything. Creditor protections vary from state to state. Florida has very broad creditor protections, so does Texas. Powers of attorney, different states have different requirements for powers of attorney. Florida needs 2 witnesses and notarized. I think New York now does as well. Springing powers, Florida doesn't recognize. They have to be effective at once. Florida and New York, you can get legal fees if somebody unreasonably doesn't accept it. So if I'm an agent and I give Jonathan my power of attorney over my principal's account, and his firm doesn't recognize it, and we bring a legal action to compel his firm to recognize it, we may be able to recover legal fees. Different states have different provisions for living wills and healthcare proxies. Some states have sample forms, some don't. Ethics rules. Obviously, a lawyer or an accountant, by the way, or an enrolled agent in any state can practice before the IRS, and you can ask to be admitted pro hoc vice and to appear in a specific case, which I've been admitted pro hoc vice in several cases in Connecticut. I need local counsel there to work together with that local counsel. And Florida says this is a pandemic rule. You can work remotely out of your if you were running away from New York to Florida, and then of course you came back later when the pandemic hit there. But they would let you work remotely if you were not holding yourself out locally and just working on non-Florida matters. This is probably true in any state. If you're not admitted in Florida, you can't prepare deeds to Florida real estate. You wouldn't want to because you wouldn't really know what you're doing anyway. Roth conversions. If you're moving from a high tax state to a low tax state, maybe you want to wait until you move to the low tax state, and vice versa. If you're moving from the low tax state, maybe all other factors being equal, maybe you want to do the conversion before you move to the new state. And then there's a couple of slides. You don't really have time to go into the weeds, but there are tremendous income tax benefits to Roth conversions, and you can convert at no higher than 24% up to close to $400,000 of income. So sometimes you want to convert all at once, sometimes over a number of years, and you want to take into account state income taxes in your state income tax and your beneficiary's state income taxes in deciding whether to convert, how much to convert, when to convert. Remember, state income taxes range from 0 in about a half a dozen states up to close to 14% in New York City and 13 0.3% in California, and a bunch of other states go up to around the 10 range. You've got Minnesota's around 9 or 10, and Oregon's around 10, and New Jersey is a little over 10 in the top bracket. And I think there's a few others. So if you're in the top bracket, you're not just 37, you can be 47, or you can even be 50 or 51, depending on where you are. So the state income tax is an important factor in evaluating Roth conversions. So I think that pretty much winds up our time within about a few seconds of 30 minutes.
Great. Thank you so much, Bruce. And if anyone has any specific questions, new business opportunities, or any other issues they'd like to discuss, please feel free to reach out directly to Bruce or myself where appropriate. And I'll be sure to include his contact information in the follow-up email to this program. As I mentioned at the onset, the goal of these programs is to stay up to date on timely wealth management related topics and to collaborate where appropriate. And I think we can all agree that the clients who are best prepared are the ones who are served by a team of knowledgeable advisors. Three more quick items before I let you go today. First, my next webinar is on Thursday, October 16th on structuring buy-sell agreements right, what advisors and owners need to know, featuring Jack Elder of Comprehensive Brokerage Services. And I'll be sure to send out the invitation to this program in the coming days. In the meantime, if you have a friend or colleague who'd find these webinars of interest, they can subscribe to my webinar distribution list by emailing me with the word webinar in the subject line. And my email is jonathan@parkbridgewealth.com. Second, you can follow all my work on X and Instagram at Jonathan on Money, and by connecting with me on LinkedIn. You can also listen to my weekly podcast called Jonathan on Money, which is available on Apple, Spotify, or wherever you get your podcasts. And you can watch my practical planning videos, which I post several times a week, by following me on YouTube at Jonathan on Money as well. And third, please take 30 seconds to fill out my survey at the end of this program. It helps me improve my webinars and provide timely and interesting content to attendees. I thank you in advance for that. And with that, this concludes today's session. Please stay safe and healthy and have a wonderful day, everybody.